And that counter is if the state would consider 2 TDC and or 10 years probation.
At this time, we're not willing to accept it. I will speak to the victim and I'll get back to you, Mr. Lozano and Mr. Carmona, about the counter, but I do appreciate it.
Thank you.
Okay, so we won't be back then until the final hearing plea deadline before the May trial setting. Okay.
And Judge, can I clarify? They're asking for 2 TDC and 10 straight instead of 5 TDC and 10 straight?
No, either one or the other, not to serve out the time and then probation, just
Okay.
one or the other.
And it's something he's willing to plead to as early as next week?
If you are willing to accept one of those, he would accept it.
Okay, Your Honor, I will reach out to the victim and I'll get them an answer.
Well, then in that case, then I'm going to leave those settings, okay? The April 5th, just the April 5th final hearing plea deadline. We won't have the trial setting, but I'm going to leave that April 5th setting. It looks to be at 9 a.m. But if you think it's going to be, if you all come to an agreement and you think it's going to be a plea, we can squeeze it in at 3 o'clock, okay?
Thank you, Your Honor.
All right. Thanks a lot.
Thanks,
Thank you.
Cesar.
Thank you.
All
Your Honor,
right.
may I be excused?
Yes, nice to see you, Ashley.
Thank you, Judge,
Okay,
you too.
take care. Okay, so let's go with Mr. Gomez, I guess. Or actually, no, I'm sorry, Annex. Can we do Ms. Reyna? Sorry, Ms. Rago. Let's take care of Ms. Reyna
That's
first.
okay.
We'll get some clarity on that one. Okay, go ahead, Mr. Marufo.
In cause number 2022-0D00534, State of Texas versus Reina Rivera. Announcement of counsel, please.
Robert King for the state of Texas.
Cesar Lozano, on behalf of Ms. Reina Rivera, ready to proceed, Your Honor.
Okay, and we had rescheduled this from last week because we had some documentation that the court had failed to provide to defense counsel, but I think that was a waiver of arraignment. I did review it. We did have that submitted with Ms. Reyna's with Ms. Rivera's signature. But there was some issue. I don't know if there was going to be a motion to withdraw forthcoming, but I don't see one filed. So Mr. Lozano, are you all still representing Ms. Rivera?
Your Honor, I think there was a conversation. I think you're referring to a conversation that we had with Ms. Rivera with regard to some possible doubts as how to proceed. However, she did call us after we had sent those emails to the court and said that she did wish to proceed. So I think the only thing I wanted to continue with this hearing is just to make sure that Ms. Rivera is sure that she does want to proceed or not.
Okay, Ms. Rivera, it is, in terms of what the court has scheduled you for, we had an indictment on February 24th. Normally that would be followed by a slate of hearings that would lead up to a trial date. I'm assuming, and I'm not asking you to tell me anything, but that you would have conferred with your attorneys. But we have a plea set. There's, from my perspective, no rush. So if you need time to think, your attorneys know, I know you're in custody, so know that there are different things that they can do with respect to a bond hearing or other things. If you're undecided, what I'm telling you is no one is forcing you to plea, okay? Now it is also your decision if you want to go ahead and plea. We're set for a plea, but that's only because the court has received papers indicating that that's what you want to do. So it's up to you.
That's correct, ma'am. I want to proceed.
Okay. So with that said, then let's go ahead and get started with the plea. Ms. Rivera, I'm going to be asking you questions regarding paperwork that you may have reviewed with your attorney, so I need to swear you in. Would you please raise your right hand? Ma'am, do you swear or affirm that any testimony you provide would be the truth and the whole truth, ma'am?
Yes, ma'am.
Okay, you can put your hand down. Ma'am, would you state your name for the record?
Reina Rivera.
Ms. Rivera, as I mentioned, I'm going to ask you about documents you may have reviewed with your attorney regarding your plea, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Rivera, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Yes, ma'am.
And did you understand everything contained within that document?
Yes, ma'am.
Mr. Lozano, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe she understood the admonishments, rights, and consequences of giving up these rights by entering a plea in this case?
I believe that she did.
Ms. Rivera, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Mr. Lozano, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor.
Ms. Rivera, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes, ma'am.
Okay, is there any condition that has been diagnosed or anything else that you're experiencing that is preventing you from understanding what we're doing today?
No, ma'am.
Have you been able to effectively communicate with your attorneys at every stage of your case,
Yes, ma'am.
including regarding your plea today?
Yes, ma'am.
Okay, nobody is forcing you to make your plea today?
No, ma'am.
Okay. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Santa Ana, California.
Okay, so in this case, ma'am, you were charged by indictment with the offense of driving while intoxicated, third or more offense. To that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty, ma'am.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element, the offense charged, driving while intoxicated, third or more, beyond a reasonable doubt. Judge, the defendant is pleading to 7 years of confinement in the Texas Department of Criminal Justice with any credit for time served. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 is the indictment.
No objection, Your Honor.
Without objection, states exhibits 1, 2, and 3 are admitted. And I'm sorry, the plea agreement was what?
7 years TDC.
Mr. Lozano, is that your understanding of the plea agreement?
It is, Your Honor.
And Ms. Rivera, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I was to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Ms. Rivera, do you recall reviewing that document with your attorney and signing it?
Yes, ma'am.
Signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of driving while intoxicated, third or more offense, and I will assess your punishment pursuant to the plea agreement at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. Did I say 7 years? Yes, 7 years confinement. You will receive credit for any and all time that you have served. Is there anything further, Ms. King or Mr. Lozano?
Nothing further, Your Honor.
Nothing further, Your Honor.
Good luck to you, Ms. Rivera.
Thank you, ma'am.
Thank you. All right, now we can take Kevin Gomez. Thank you, Ms. Frago. All right, so I think I was confused the entire time on Mr. Gomez because I kept thinking we were gonna revoke him to time on his probation case, but what you're wanting to do is just revoke him to straight. Is that right on his probation case?
Yes, Your Honor.
Okay, but see, I don't know that I want to keep him on probation, Mr. Gomez. So let's go ahead and call these cases. I'm not, Mr. Marufa, let's go ahead and call it.
In cause number 2021 0D0 3092 and 2019 0D0 4903, State of Texas versus Kevin Gomez. Announcement of council.
Roa King for the state of Texas.
Samantha Rago for the state of Texas on cause number ending in 3092.
Okay, and so let me ask this. Well, sorry, go ahead, Mr. Lozano. Did you announce?
Cesar Lozano on behalf of Mr. Kevin Gomez, ready to proceed, Your Honor.
And Mr. Gomez is appearing from the jail annex. Let me ask this, Ms. Rago, was your, I don't recall from the plea papers, I don't think I saw this on there, but was your rep on the new case contingent upon an adjudication on the probation case?
It wasn't, Your Honor. I left it up to Ms. King with what she would like to do with her case.
Okay, so let me see. Why, Mr. Gomez, am I going to keep you on probation? Mr. Lozano, why am I going to keep him on probation? He's pleading to the new offense. I had a whole bunch of trouble with him on that 2019 case. I initially, when we got the new case, you know, had heard a bunch of stuff about how, you know, wrong place, wrong time on the new case, but he's pleading to time. So he's got that 2021 conviction. I mean, why are we going to keep him on probation? It's just going to be more hand-holding. I know it's a conviction, but why am I going to spend time on Mr. Gomez? If we've got a conviction, why are we not just pleading him to time there too?
To be honest, if the deferred is going to go away, I believe that Mr. Gomez and I had talked about if the court would be willing to accept 2 TDC on that probation case, then he would proceed with the plea of true. Now, there was some, because of that confusion, I believe that we were still kind of weary about what the court was going to be willing to accept or not. And so even though there was that initial thought in the initial negotiation that he might be able to stay on probation, but I think we do agree with the court in the sense that if he's going to be convicted anyway, he may be better served with moving forward with his life, serving out his time, and then being able to kind of resume to some sort of normalcy here.
Mr. Gomez, do you want to be on probation?
I mean, I am willing to work with y'all. I'm really willing to put on my part again and get it back on track.
So how am I supposed to believe you? Because you know what we went through all through COVID, right? All through COVID, even before COVID, you had so many hiccups. And then during COVID, I just remember, you know, as we all got acclimated to all our remote hearings, you were like the one person I saw every month. Every month I saw Mr. Gomez for everything. I knew about how your mom was worried, probation was worried, everybody was worried about you, working, not working, getting your education, everything. For what? And now you've been sitting in jail for 200 days, more than 200 days.
I was really ready to continue so I can continue going to school and keep going to college and continue my career that I was going to keep going after in high school. This is why I finished my high school diploma. And I'm really willing to use that as a distraction for me to keep going good in life.
Carla, do you have, did he finish school?
Let me check that.
But what's the new one? It's a state jail. And that's what he's pleading to, right? 7 months state jail.
Yes, Your Honor.
I got my high school diploma on August, 10 days before everything happened. So me coming here, I got it at Options High School. I had my graduation and everything.
I want to recall that, Judge. I'm just trying to pull it up. I'm sorry.
Mhm.
But I do recall something like that. It was right before the new offense in August. Let me just double check.
All right, we're gonna do the plea on the 2021 case, okay? We're just gonna do the plea on the 2021 case. All right, so as to cause number 2021 0D03092. Mr. Gomez, I'm gonna swear you in on that case only. Raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Put your hand down, state your name for the record, please.
Kevin Gomez.
Mr. Gomez, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Gomez, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Lozano, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, we have.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea in this case?
I believe that he has.
Mr. Gomez, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Mr. Lozano, do you have any reason to believe your client is not presently competent to enter a plea?
I believe that he is competent, Your Honor.
Okay, Mr. Gomez, have you ever been found incompetent by any court?
Yes, ma'am.
Was there a previous finding of incompetency? If so, when was it? You recall when that was, Mr. Gomez?
Oh, yeah, I recall. I got that wrong. I'm sorry about that. I mean, no.
Hold on.
I really
I don't believe.
don't understand what that word means.
Has a judge ever said or issued an order saying that you did not have the mental capacity to handle your personal affairs? Did they ever send you to a doctor to be examined, anything like that?
No, Your Honor.
Have you ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Have you been able to effectively communicate with your attorneys at every point?
Yes,
At
ma'am.
every point during your case, including regarding your plea?
Yes, ma'am.
Okay. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent in your plea today. Mr. Gomez, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso, Texas.
Okay. To this charge, engage in organized criminal activity. What is your plea, guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
We'll find you're making your plea freely and voluntarily. Ms. Rocco, would you summarize the evidence, please?
Yes, Your Honor. If the state of Texas were to proceed to trial, the state would have proven beyond a reasonable doubt that on or about the 23rd day of August 2021, in El Paso County in the state of Texas, Kevin Gomez did and there, as a member of a criminal street gang, intentionally and knowingly commit the offense of assault causes bodily injury. At this time, the state moves to enter into evidence States Exhibit 1 and 2.
No objection, Your Honor.
Without objection, States Exhibits 1 and 2 are admitted. What is the plea agreement?
It's 7 months state jail facility, Your Honor.
Mr. Lozano, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Gomez, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Mr. Gomez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. We'll find you guilty of the offense of engaging in organized criminal activity, and I will sentence you according to the plea agreement to 7 months confinement in the Texas Department of Criminal Justice State Jail Facility. You will receive credit for any and all time that you have served. Is there anything further on this case, Mr. Lozano or Ms. Rago?
Nothing from the state, Your Honor.
Nothing further, Your Honor.
Okay, thank you, Ms. Rago. I don't know if you have anything else. If not, you're good to go. All right.
Thank you. I appreciate it.
Sure. So now on the 2019 case. Mr. Gomez. So I think we had him on the gang caseload. Ms. King, do you have any input on this?
Your Honor, I don't believe he should remain on probation. There has been multiple tries, but that's my opinion. I'll defer to the court.
Well, okay, so then that's my question. Why didn't we submit it then as a 2 TDC or some TDC rec rather than just a revoke to straight? And that was my question from the very beginning. If you all don't want to keep him, my thought is we either revoke him to time or I'm going to leave him on deferred and he messes up. I mean, because there's no reason. I'm not going to handhold him, give him a conviction, handhold him because it was too much. If he was making progress, you know, he's got another hit now with a conviction. I mean,
When you come back,
but you know, it's not a second degree. I'm
And
not
Your
really
Honor,
sure. Yeah, I'm not really sure, Mr. Gomez. I'm not really sure if I trust you to put you out there, but 2D TDC, I mean, he's gonna be out there pretty quick. Go ahead, Ms. King, sorry.
Your Honor, I was just gonna say that we've been back and forth. In the beginning, my rec was to actually just do a play of true and just time. And then there was the confusion with the BPU case. So at this point, I'm not too sure where we stand anymore. As I have not had contact with Mr. Lozano is what I mean.
Okay. Mr. Lozano?
Yes, Your Honor, thank you. Judge, again, I mean, as Mr. Gomez has indicated to the court, he still is willing to work. I mean, I understand that he has put himself in a situation where it's made it difficult for either the court or maybe even the prosecutors to believe that he can complete this. However, you know, when he's confronted with these questions, he's still determined to prove that he can complete the probation. Now, of course, you know, if the court is willing to leave him on deferred, I think he understands the great benefit of not having a second-degree felony conviction in his background. It's a huge difference between a state jail and the second degree. And so if he's as serious as I think he is about being on probation, then I would ask the court to give him that opportunity, Your Honor. He's been locked up for quite some time. And so, you know, if he's still willing to give another, I don't even know how many more years, 8 more years of his time, and then I think he's serious about it.
Ms. Pineda, what was the recommendation on the last case summary? I don't remember. Was it a revoke to straight?
Yes, Your Honor, that has been the probation department's recommendation. Well, it's being really, sorry, Judge, this one goes back and forth. It was just to continue on supervision, Judge. He is in the, like we mentioned, he is on the intensive probation program in the gang caseload already. He would have 4 years remaining in probation.
Was the let me ask, was the modification, I know where there was a delay on the modification to the gang caseload. Was that modification, did it happen before or after he picked up the engaging?
The modification happened right before, Your Honor. So we had been coming to court and then he was modified. He was on probation. He got modified. He was going to school. He was attending EHN services. And then this new arrest happened in August or July.
Okay.
Of 2021.
Okay. All right. So I'm going to reset his probation case for 2 weeks. Mr. Lozano, you see the time credit he has there on his probation case. I know he wants to tell me something right now, like he's going to comply with probation and all that stuff, and it sounds good. And there is a benefit to it. But there's not going to be any leeway for him. And, you know, maybe he needs to have a heart-to-heart with you. But he has, I think he has those options. But it's not going to be a revoke to, it's not going to be a revoke to strike. That makes no sense to me. So in 2 weeks, you know, we can either, I will look at, when we come back in 2 weeks, I want to know some things because I know parents were very vocal. Mom was very vocal about keeping him on track, things like that. I want to know some things if he's gonna want to stay on deferred. You know, we're gonna look at tightening up some conditions. But if not, then we're gonna go the revoke to time route. Okay. All right. Okay, so we're coming back in 2 weeks on the 2019 case. All right, thank you, Mr. Gomez. Thank you, Mr. Lozano. I think that's all you have now, right?
Thank you.
Yes,
Right.
Your Honor. May I be
Okay.
excused?
Yes, sir. We don't have Brock here, do we? Why isn't he here? Okay,
No, man.
all right, who's next?
Ms. Nava is here on behalf of Sarah
Mm-hmm.
or Esparza. Annex, can we have Esparza?
Yes, sir.
Thank you, Marissa. All right, go ahead and call it, please.
In cause number 2019 0D05117, State of Texas versus Michael Esparza Alvarez. Announcement of counsel, please.
Roa King for the state of Texas.
Alyssa Nava, Your Honor, on behalf of Ms. Sarah, representing Mr. Esparza, and we're ready to proceed.
Okay, and Mr. Esparza is appearing from the jail annex. We're scheduled for a bond hearing. You may proceed, Ms. Nava.
Yes, Your Honor. So Mr. Esparza did surrender himself to custody on March 15th. Prior to his incarceration, he was working for his father, Arturo Esparza, at Esparza Construction. He would continue to do so if released. He does framing, walls, roofing for his dad's company, and anything else that he needs. Ms. Sarah has been in contact with Mr. Esparza's father, whose business has been suffering without his son. The dad is struggling to find other workers to help him, and his mom is sick with diabetes. Prior to being incarcerated, not only was Mr. Esparza working, but he was going to AA and doing community service. While he's been incarcerated, he has begun to do trustee work. He's been working 10 hours a day doing laundry. And if he does remain incarcerated, he will continue to do so. Additionally, we understand that he has had some difficulty connecting with the probation officer. There are times where the probation officer is called and he has been scaffolding up high, and so it would be dangerous to answer. He does still wish to remain on probation. At this time, we'd ask that the court set a reasonable bond so we can try to work this out prior to or we can try to work this out with the state and that he can be out during that time. We'd ask for a straight PR bond if the court is amenable with any conditions that they wish to add along to his probation. At the most, maybe a $5,000 bond is what he could afford, Your Honor.
All right, Ms. King.
Your Honor, the state respectfully opposes the bond. So the state did file a motion to revoke probation. And one of the things that the defendant was not complying with is actually he received 3 traffic tickets. And while one of his conditions on probation is not to drive, he was not allowed to do that. Also, he actually failed to comply with the Smart Start in the home device. And that was from the months of January 2020 through December 2020, and January 2021 through June 2021, and August 2021 through December 22, and February of 2022. And Your Honor, I mean, he also has not, he did fail to submit a UA on July 31st, 2021. This is a true third, and therefore the state does respectfully oppose the bond.
Your Honor, may I provide a quick response?
Sure.
I know that my client does have difficulties doing or had difficulties with the UA because he didn't have money for the testing. And I know that he has had some issues with the unit in his vehicle. He has sent emails to the probation officer to see if he could get a different unit or a new unit, and those requests were denied by probation. But I do know that he's had some difficulty with that unit.
Ms. Pineda, does your file reflect anything like that? Any communications regarding the unit?
Not that I can see, Your Honor. I know on March 10th, there was an admonishment hearing where the probation officer was present during this admonishment. It was mostly based out of severe excessive skips on the monitor.
Right.
Now, if it's the smart monitor, which is not the interlock device, is what my understanding is, he just can't go pick up a new one. There's got to be what the court requires. That has to play a lot in it. I can't speak for the probation officer, but I know there's more to it than just calling and switching off from one day to the next regarding the machine.
They swapped out the device in October 2021, but prior to that, he had positive readings and a lot of non-compliance on the monitor. I remember Mr. Esparza.
Yes, and it's been in the past, I guess from 2021, June 2021 to February 2022, there's been skips. And then Judge, you requested the bench warrant due to not only the skip violations, but he had failed to provide testing when required.
Yeah, the skips, the positives, the driving. I mean, I know, yeah, there's a reason. There's a reason for all this. So he's at no bond, right?
Yes, Your Honor.
It's a true third. And he's driving, yeah. And he also has some failures to report. So, I mean, he doesn't have to have a bond, but what are we gonna do with it? That's really what I'm thinking about. Had probation made any kind of recommendation? I don't see one on my report. I don't know if they updated it, Carla. Do you show an update?
No, they didn't do it. It says to be admonished by the court and to have a status or review within 60 days. I guess to monitor any progress after that.
Okay. So unfortunately, Ms. Nava, I don't think we can get to the bond that you all are looking for. I'm going to give him a $50,000 cash surety bond. He doesn't have any future settings, so I'm going to do a probation status hearing in 30 days. He terms in 2024. I mean, I know this isn't yours per se, but he terms in 2024. So, you might get with Miss King, or Miss Sarah might get with Miss King and start coming up with some solutions. Options, I guess, options, but we'll go from there. 30 days probation status. All righty, thank you very much.
Thank you, may I be excused?
Yes, ma'am. Who's next?
Public defender with Mr. Cooley. Annex, can we have Mr. Cooley?
Yes, sir.
All right.
In cause number 2018-0D03237, State of Texas versus Noel Cooley. Announcement of council, please.
Roa King for the state of Texas.
February Bobbin for Mr. Cooley. We are ready.
Alrighty, and Mr. Kaholi is appearing from the jail annex. I believe we were here just a couple of weeks ago. We were going to kind of reconvene, see if we could get some resources or attention to his situation, because he was basically an absconder, right? That's basically what happened, and I think we identified a mental health angle to this case. So, do we have an update?
We do, Your Honor. Ms. Garcia is here from EHN. The court can hear her out.
Sure, of course. Hi, Ms. Garcia.
Good afternoon. Your Honor, Mr. Cooley is on mental health services. He has been compliant with medication intake. And I was checking in the system for a history, but I don't have history on him. Nevertheless, I was able to get ready with appointments in case he is released back to the community.
Okay, where would we be releasing him? Where are we sending him if we let him out?
Yeah,
Oh, okay. Go ahead, Ms. Garcia.
no, go ahead.
He does have a residence with his parents. Judge, I have spoken to his dad, and he is welcome to return home with them in Northeast El Paso.
Okay, do we know dad's name?
Yes, Harvey Coley.
Okay, and this is okay. And the appointments, Ms. Garcia, what are we talking about? Like, is it
Yes.
it's just a sequence of what are we doing? Like, he's going to be sent home with meds and a slate of appointments.
Okay. Since he's already on mental health services in the jail, once he is released back to the community, a script will be called into the pharmacy located on Litra Union Tray with CVS. This medication is to be picked up by the client or the family. Then he has an appointment on April 1st at 12 p.m. This appointment at 1600 Montana. He will be meeting with Maria Canizales, therapist, to determine the level of need. It's an assessment. Depending on that, he will be placed on the level of need.
All right. Any other input, Missy Bobbin?
Judge, there is a criminal mischief case that is pending as well. So that's also holding him in jail. It's a $300 bond. I had reached out to Ms. King to see if we could resolve that case because it was like a window that was supposedly $100 from 2019 that had been filed and just kind of been sitting there. So I was hoping that we could either agree to dismiss it or something. My understanding, Ms. King did just message me that restitution was paid in that case. Hopeful that perhaps we could just dismiss it and continue him on probation so that we can get him wrapped up so that he could make it to the April 1st appointment. Because that other misdemeanor case is in CC2. So if we can't dismiss it, then we'd have to request a bond hearing over there.
Right. So has that been able to, have you all agreed on that?
Your Honor, the state is not opposed to dismissing the misdemeanor case.
So I'm good. Look, basically, Mr. Coley, what they're requesting and what they presented today is giving you the opportunity to perform what you had not done on probation here. I understand there are some external or other factors that affected your ability to perform well on probation. So basically, this is a second chance, okay?
Yes, ma'am.
What I'm telling you is I'm in agreement with it, but this will be your last chance, okay? So what Ms. Garcia and Ms. Ibavan has presented to the court today is that they've got a regimen of mental health treatment, meds, things of that nature. Your family is supportive. I am in agreement with all that, but that is not just like, just, oh yeah, I think that's a good idea. It will be a condition of your release, which means that I am agreeing to release you on a PR bond that will conform to the conditions of your probation and will contain all the conditions that you have to remain compliant with all your mental health treatment, all your appointments. You were to reside with your father. You cannot change your place of residence without court permission. You may not leave El Paso County. You are to follow all the conditions of your original probation. I'm going to put down there that he is to be released to his father, okay, to Harvey Coley. Let me see. And then I guess the conditions, Marissa, are just going to be that the additional conditions of probation, to be compliant with the conditions of probation. And so we will do a status in 60 days. Okay, I'm going to require that Mr. Coley appear virtually. What that means. Okay, so the clerk is telling me it can be a release to the streets and release to just to the father's name. All right. It's kind of what we're doing right now remotely, where we kind of operate on Zoom. I'm going to need you to do that for that hearing in 60 days, and Missy Bobbin and probation can help you do that. And we can accommodate if you're not able, if you don't have the tools to do that. But I'm going to ask or order that you appear in 60 days just to keep to check in on you and make sure that everything is going okay. If at that point you're in good shape, you're going to your appointments and you're doing well on your probation, then I'm not going to see you anymore. You're going to go do your probation and hopefully be done with your probation, and you go on with your life. Okay.
Yes, thank you.
Okay, so that's what we're going to do. We'll just do a release to the streets, but list dad. But we need to make sure we put, if the mental health conditions were not previously on his conditions of probation, those need to be on there now.
Yes, Your Honor.
Ándale pues.
Judge,
Mande.
Vacation. Is the motion remain pending, subject to the 60-day status, or are we just going to dismiss that and with the modification? I just want to clarify.
We can dismiss the motion.
Okay.
This will be second chance. We'll start now. Okay, so basically, Mr. Coley, anything that didn't happen previously, we're just starting new. This is day one. So
Yes,
don't be out of compliance from here going forward, because it will count against you and I'm not going to give you another chance. But things come up, okay? When things happen, life bumps happen, you work with probation, okay?
Yes, ma'am.
Handle them responsibly. Don't go and just say, no, you know what, forget it. You work with probation. They will let me know and I will work with you, okay?
Thank you.
All righty. Anything else, Missy Bobbin?
Nothing further, Your Honor. Thank you.
Okay. All right, Ms. Garcia, it's so good to see you. Thank you so much.
Yeah.
Thank you,
All
Ms.
All right, who's next?
Judge, we have Carrillo Cristobal.
Where's Mr. Benjamin?
He had filed a motion to withdraw counsel, but it's not signed yet.
Yes, that isn't signed yet. That's right. So, but I think I was gonna let him out. I think I did let him out. And Mr. Carrillo, okay, let's go ahead and call that. That's right.
In cause number 2021-0D0-1748, State of Texas versus Cristobal M. Carrillo.
Yeah, right there.
Announcement of counsel.
Roa King for the state of Texas.
Okay, Mr. Carrillo, we're back. Did you hire an attorney?
Not yet, ma'am. I still, my wife still needs a little bit more time, but she's
Wow.
gonna hire one eventually.
Are you sure about that? You don't want to see if you qualify for a court-appointed attorney?
I mean, she is gonna do it, but if you guys want me to get a court,
It's up to you.
I'll wait. I'll wait for more time.
Let's go ahead and have, Mr. Lara come in and screen him. Because you're in custody, Mr. Carrillo, I don't want to just keep pushing this back and back. I'd rather have a representative from CJC, which is the department that handles court appointments, come in and screen. And that way I know that if you qualify, I know I can appoint someone. And if you decide to hire an attorney, great, you get your own attorney. I don't have to keep them on there. But I am not comfortable leaving you in custody without an attorney, because you'll tell me another week and another week and another week. And next thing you know, we'll be pushing up against your trial date and you still won't have an attorney, right? Okay. So let's go ahead and get Mr. Lara in here, Mr. Marufo, to go ahead and do the interview. What will happen is that gentleman will come in here. They're just going to interview you about like financial questions. Okay, it's just a financial interview. And if it's not Mr. Lara, there will be somebody from his office. I messaged Lara. Thank you, Erica. So this is the last case, right?
Yes, ma'am.
Okay, so we can go ahead and get off